May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 3 and 4, my lord.
Yes.
In this case, my lord, arguing counsel are from Kolkata, my lord. Due to some personal difficulties, they could not appear today, my lord. Kindly pass over the matter for today, my lord.
It is stated that arguing counsel, Mr. So and so, is not available to attend the hearing today due to some personal difficulty. A request is made to adjourn the matter. Arguing counsel for the petitioner, appellant,
Both sides,
Both
my lord, both sides.
for both the sides.
My lord,
In view of the submission so made, re-notify in second week of December.
my lord, may I pray for a convenient date, my lord?
Second week of December, it will come out.
12th of
12th December, all right.
March of April.
Much obliged, my lord.
I beg to mention item 11. Lordship. I am led by Senior Counsel Mr. P.K. Jasami in this matter, Lordship. He's preparing a catalytic operation. Lordship.
Okay. This is a bunch of matters.
Bunch of matters, Lordship.
It is stated that Senior Counsel Mr. P.K. Goswami appearing in writ appeal number 253/23 is undergoing some medical treatment, and thus a request is made to adjourn the matters. The other side has no objection. List after 2 weeks.
Lordship, can it be 4 weeks, Lordship?
4 weeks. All right.
Deeply obliged.
May I please, Your Lordship? I beg to mention item number 17 of today's list, Your Lordship. In this case, Your Lordship, we have filed an IA today, Your Lordship. Let this matter come up on Friday along with the IA for stay, Your Lordship, of the operation.
Mr. Botakout submitted that he has moved an interlocutory application for seeking interim relief. Let the same be tagged with the record, and the matter be listed for orders on 10th. 10th or 11th? 10th.
Deeply.
May I please, Your Lordship? Lordship, I beg to mention for listing, my lord.
What do you want? What matter?
Lordship, matter regarding LPG distributorship, my lord.
You are against a single bench order.
Yes, my
What
lord.
is the date of the order?
Long back.
Long back. So then what is the urgency? It will
Admission
come up
stage.
in routine.
Admission stage, my lord.
It's already listed matter.
No, my lord.
Then a fresh matter, if it's the order was passed long back, what is the urgency? It will come up in routine. The registry will list it automatically. Yes.
Lordship, I beg to mention item 21, Your Lordship.
Yes.
Your Lordship, I need some time to file reply affidavit in response to the affidavit of modification.
You won't file affidavit in reply.
Yes,
This
sir.
is an appeal. Why affidavits are required?
Actually, Your Lordship, the contention of the respondent side is that the guideline on which they have relied, Your Lordship, our contention is not applicable in our case because
I'll learn counsel for the appellant place for time to file an affidavit in reply. List after 4 weeks.
obliged. 20.
May I previous Lordship, previous Lordship for adjourn the item number 22 of this today's list.
22.
My lord,
What happened? Why do you want an adjournment?
my lord, perhaps a reply not filed till today,
This is an appeal.
government segment.
Reply is not necessary, my lord.
They don't want to file a reply.
My lord, Mr. J.I. Borbia is not,
You state so, you don't want to do it.
Yes.
Don't place it on the head of the government. All right. It is stated that arguing counsel, Mr. Borboya, is not available today, and a request is made to adjourn the matter on his behalf. List of 4 weeks as prayed.
Obligement.
Orders, item 7.
My lord, in this case, we were directed to file affidavit, my lord. I require a little bit of more time. It has gone for vetting.
Your lordship, I have instructions to withdraw the PL, your lordship.
PIL. What is the PIL about? Let us know. What is the subject matter of PIL, Ms. Goswami?
My lord, they challenge, my lord, the grant of certain micro irrigation program, my lord, setting up in the particular area, my lord. And they said that these things were not done or money was siphoned off, my lord.
So then there, once the court has taken,
It dates back to 2009, 2010. They had come in 2011, my lord. And in the meantime, my lord, things have been settled down and the projects have been, instead of 20 projects, scaled down to 8. And the projects were executed. And there was also a vigilance case, my lord. And that has also given, my lord, its report.
Closure.
Yes.
All right, then Mr. Goswami, then Advocate General, Additional Advocate General, Mr. Goswami submits that the projects in relation whereto, comma. But there was a trial which was going on. What happened?
No,
to
my lord, that SIC, my lord, that
we see the order dated 15th December 2014 that a designated special court was ordered to be designated for trial of the.
yes, my lord, that vigilance, they have submitted their, my lord, inquiry report there, my lord. So that was closed. That is closed, my lord. That vigilance case is closed, my lord. In the special court.
Do you have a copy?
Yes. We have
My lord, my friend may have copied.
a copy.
All right. This court is apprised that the vigilance case instituted in relation to the alleged irregularities in the construction / development projects under the MIP schemes, which is the subject matter of this PIL, has resulted into a closure report with the conclusion that the case has been returned in FR on account of mistake of fact. The sessions judge cum special judge within bracket WSD bracket close UPR has accepted the closure report and the case has been disposed of by order dated 28/11/2016, which was presented to the court for perusal during the course of hearing. Mr. Goswami further states that the projects in question have been executed and now nothing survives in this PIL. So, then counsel for the petitioner at this stage submits that he has been instructed to withdraw the instant PIL. Hence, the same is closed.
Item number 8.
I appear on behalf of Mr. Yukena in this matter, Lordship, for the respondents number 2, 3, 4, and 5. Lordship, we were required to file an affidavit.
Then counsel, Mr. Your good name, please.
Lordship.
Your good name.
I am MP Sharma, Lordship.
MP Sharma appears on behalf of the respondent numbers 2,
3, 4, and 5.
2, 3, 4, and 5,
It
and
is-
submits that an affidavit is required to be filed on behalf of such respondents. He seeks 4 weeks' time to do the needful. List after 4 weeks.
It will be filed today itself, Lordship. And it will proceed.
That he would be filing an affidavit on behalf of such respondents during the course of the day. The affidavit upon being filed be brought on record. List up to 2 weeks.
Obliged.
Much obliged.
Item number 9.
May it please your lordship, my lord, respondent number 11 and government, they have filed affidavit in opposition. I need to file my reply to that. My lord. Matter relates to, my lord, the presence of magnesium carbonate in, my lord, pan masala, my lord, which is responsible for.
Then counsel, Mr. Goel, representing the petitioner, submits
Well,
that
state though, I'm told that the affidavit has been filed, but we have not received any copy of the affidavit.
of
The state
Eh,
affidavit.
state's affidavit. All right. Submit that.
Your Lordship, I'm extremely sorry. I have got telephonic instructions to appear for respondent number 5. I'll also be filing my Wakalafnama and also my reply. to this time.
And in fact, in the PIL, I was going through yesterday, the rules which have been already been repealed, they are referring to that rules. And magnesium carbonate,
We'll
they are
consider-
saying
we have-
negligence, even under the rules, it is not barred. There are.
It's not
items
barred,
that-
but the percentage, there is a calibration of the percentage.
Well,
You
the-
can't exceed a particular percentage.
But they are saying magnesium carbonate below, even the child food also, the magnesium carbonate.
Come
there.
what may, sir, if the standards say no more than a particular limit, you can't exceed that.
So if they.
So let the affidavit, you
In
let
fact,
them,
in-
let them
in
respond.
my humble submission of the PIL, in fact, this PIL, but at least, I may say, the PIL which the Supreme Court said in the real term, the PIL, I will not term it, my lord, that is the PIL.
My lord, very easy to
It's,
say, my lord,
it's
but
easy for you to say, but we feel that's a very important issue which they have highlighted. We'll deliberate upon it.
My lord,
Yes. Then Counsel Mr. Goel, representing the petitioner, prays for time to file an affidavit in rejoinder to the affidavit filed on behalf of the respondents numbers,
11 and government, your lordship.
on behalf of the state respondents and the
And
respondent number 11. And Counsel Mr. Your good name, please.
R.B. Fukan.
R.B. Pukun puts in appearance on behalf of the respondent number 5. He also desires to file an affidavit on behalf of such respondent. The pleadings be completed by next date of listing.
my lord, we will also like to file the reply to the state, but the state has not served the copy, my lord, so.
My lord,
Procure a copy.
I am appearing for the respondent number 6 and 10, my.
Pleadings be completed by next date. List after 6 weeks.
deeply.
Item number 10.
6 and 10, my lord.
6 and 10 mark his appearance.
Much obliged, my lord.
Yes.
May I please your lordship? Present interlocutory application has been filed, my lord, for condemnation of.
What is the matter, Mr. Counsel?
Main writ appeal has been filed, my lord, preferred, my lord, against the judgment dated 1/3/2023,
What is the judgment under appeal?
my lord.
What has been decided by the learned single judge?
Yes, my lord.
Anyhow, who is there for the respondents?
May I please.
Do you oppose the prayer for,
Secondary education.
Condemnation.
do you oppose the prayer for condonation?
No, your lordship, 90 days.
Condonation application allowed, the rate appeal be numbered and listed for admission.
Highly obliged, my lord.
Deeply obliged.
Item number 16.
Yes,
Please, your lordship, my lord, I'm told, my lord, by my learned counsel, my lord, that the copy of the affidavit in opposition, my lord, has not been given to him. I'll supply a copy today, lord.
affidavit in opposition.
Lordship, additional affidavit, lordship.
Additional affidavit.
Counsel for the appellant to supply copy of the additional affidavit to Mr. SCKL, Standing Counsel, Government of India,
Custom.
within 2 weeks. List thereafter.
Lordship, so I'll supply within 2 days. 2 days,
During the course of the day, all right, within a week. Kar dijiye.
lordship.
Item number 18.
What is the matter, gentlemen?
Lordship, the judgment is at page, lordship, 95.
This was an appeal which you filed in the year 2018.
Lordship,
What was the prayer in the writ petition?
lordship, my writ petition was challenging, lordship, the termination order, lordship.
What was the nature of your appointment?
Lordship, on that point, the case was not decided, lordship.
We are asking you.
Lordship,
We are asking you.
lordship. Nature of appointment was regular appointment, lordship. In the process of law, I was appointed, lordship, as an internal auditor, lordship. Initially, for probation, 6-month probation period, I completed that. My service was confirmed, lordship, and thereafter I was dismissed, lordship, without
Okay.
any notice.
So is the dismissal based on a criminal case or what?
Lordship. No, lordship, no criminal case is pending, lordship. There
Then-
was a complaint, lordship. And the complaint was lodged before the incidents, lordship. Total, lordship,
Oh, but the finding of the learned single judge is that your employer is not a state.
no,
Oh, how do you meet that observation?
for that reason, lordship, I have, it is a state, lordship. It is
There is a
state-
judgment by this court. There is a judgment by this court.
Lordship, I don't know, lordship, but lordship, it is a state, lordship. NERCOM is lordship,
You may argue so, sir, but there is a judgment of this court.
lordship.
How do you meet that judgment? Tell us. How do you meet the ratio of that judgment? Ruzik Belai versus Union of India. Rusing Belai. What is the pervasive control of the state government on your society?
Lordship, yes, lordship. There is 100% lordship finance, it is, there is 100% finance from the Union of India, lordship, in this
Let us see.
society, lordship.
Where is your pleading?
Lordship, lordship, may kindly come to my pleadings, Lordship. I have
Yes.
categorically stated, Lordship, page number 2, Lordship, that the Northeastern Region Community Research Management Project, NERCOM, has been established basically for livelihood development in upland areas. And the state project is a project of Ministry of Development of
Yes,
Northeastern Region.
Ms. Counsel, what do you say? Have you filed a reply to this aspect in the writ petition?
I am appealing for respond number 1, my lord.
Yes.
Respond number 2, file an affidavit, my lord.
To
At
file an
page
affidavit.
72,
Page?
72,
So all right, we'll issue notice then. Third, issue notice to the respondent.
72, paragraph 3(1).
Then counsel, Mr. Sorenso appears for the respondent number 1. Steps for service upon the other respondents be taken within 3 days without process be issued. Apparently, the view seems to be incorrect. If there is a control of the central government and the funding is by the central government, the institution must be considered to be a state. Yes.
Obliged, Lordship.
Yes.
Item number 19.
Please, ma'am.
What is this matter before Supreme Court, Mr. Balagopal? This
Because
matter before Supreme Court, what is the matter? State versus Amos Sep. There is an order placed on the record of this writ appeal. There's order by Honorable the Supreme Court in SLP. What is it about? I will share it with you. Does it have some relevancy to this very controversy?
Lordship, in that case, I was appearing and this honorable court directed the respondent to
Just hold on. Pass on this side.
provide regularization to the petitioners. Amos Sep.
Whether that SLP has been decided finally,
No, it's still pending, Lordship.
then would it have that SLP have a bearing on the outcome of this appeal?
Lordship, this is just a matter of here, Lordship.
Sir,
The present respondent petitioner were first appointed as
We are asking you,
contingency.
madam, simple question.
Lordship.
My lord, this is a different case. I appeared.
This is
Completely different. I appeared in Supreme Court.
Ms. Balgopal, we just came across this order lying in the file. That's why we made this inquiry.
In fact, I appeared in this case.
Okay,
This is an entirely different case.
okay.
This is regarding that Shiksha education, which is increased by the
Regularization.
central government,
Okay,
where their salary was being paid substantially by the central government. Later, central government reduced its exposure and asked the state government to pay.
yes.
State government initially did not pay, but because of the situation in which they were placed, they started paying.
Okay,
The issues are completely different.
okay, just,
The
we
question
just
there
made
was-
an inquiry
Yeah.
because the order was lying in the file.
Oh, I'm
Okay,
sorry.
Lordship.
You have placed it. is it?
No.
We don't know.
Some other
It was-
case.
it was
Incidentally,
tagged with the record.
I appeared in this matter.
It was tagged with the record. All right,
All right.
so let's proceed
lord-
with this matter.
This one, the case before your lordship today, my lord, involves only 3 questions of law. This involves certain of the respondents who were working as contingent employees since 1986. They claimed that in 2007, there was an order issued by the undersecretary to the director advising him to issue orders for giving them scale pay. This order, my
Giving
lord,
them
giving
pay scale.
pay scale.
Please.
All right,
So
Yeah.
this order was passed And this order is on page 56. Kindly see that.
Yes. But Ms. Balgopal, otherwise also a simple question. You've been using the services of these employees
Yes.
for more than 30 years.
Correct.
So then why not regularization in light of Uma Devi?
I want to make 2-3 submissions on this.
Yes.
The legal issue is, my lord. They claimed right on the basis of a particular notification issued by the government in 2015, which was a one-time measure.
Ignoring that, Mr. Balgopal,
My lord,
going on the fundamental principle of equity,
my lord.
when you are using the services of employees from a period of 10 years before Uma Devi's pronouncement, and unless you brand their appointments to be backdoor entries or purely against posts which are not in existence, why should they not be regularized? Rather than pay scale, we go a step further.
Here the issue involved was, they claimed this on the basis of the letter dated 2007. The only submission was made. They filed the petition in 2017, after 10 years. So even there are recent judgments of the Supreme Court as recent as 2023 that even if they are entitled to any right, if they slept over it for a period of 10 years, then they are not entitled to any benefits. That is the reason
They came to approach the court while they were still in service.
4 years.
No.
Yes, Lordship.
if they were in service, no doubt. But if they're
Madam, have your seat. We'll hear you. Don't worry. Don't be so anxious.
Lordship.
Yes.
So
I think
if their point is that in 2007, they came to know of it, though that letter is not in the file of the government, that's a different thing. I'm not making an issue of it. So if at all they had any right, then what the Supreme Court says is that in such situation.
State should not indulge in extortion, Mr.
That's
Balgopal.
correct, madam.
Plain and simple extortion.
In fact, as far as this case is concerned, just for your lordship's appreciation.
Do you
outside-
really, can
outside the brief,
you have countenance
outside
using the
brief,
services of a man
outside
for
the brief,
375 rupees a month?
outside the brief,
Yes.
outside the brief. In fact, we are facing similar problems in almost all departments in Nagaland. So I was consulted in this matter to come out with a policy. To come out with a policy by
Yes.
which
Yes.
this is actually minimum. Many departments, education departments,
Yes,
etc., etc. So we have to devise a policy, keeping in mind Uma Devi, which specifically stipulates that if the entry is not legal, then you can't regularize.
Have you set up a case in the single bench?
Just a minute. In spite of that, we are just devising measures because we know the reality.
Do that.
They may not be able
If you take our judgment, probably all the employees similarly situated will claim the same relief. Prima facie, we are satisfied.
Therefore, what I'm trying to say is
Yes.
that as far as this policy is concerned, this has just been referred, which we may look into it. We want to come out with a policy by which it can be a one-time settlement for many affected persons in different departments.
Yes.
The issue, a larger issue is para 19 of Uma Devi case, which says financial constraint.
That doesn't mean
Just
that
bear
you
with,
can
bear with me
go
for a
on
minute.
indulging in exploitation of employees.
These are things which I am taking into consideration for coming out with a possible, pliable issue. As far as the state of Nagaland is concerned, we are getting grants from the central government. Our main expenditure is coming from there.
Yes.
And as far as services in Nagaland is concerned, because the peace talks have not yet completely fructified, the area of revenue is very limited. Even liquor is not there. So we depend substantially on the grants. These are issues to be looked into.
Yes,
We
that's
cannot just ignore it. So taking all this.
Cannot ignore it, but are we
No,
supposed to
taking-
ignore the plight of the employees?
Taking all this into consideration, we are now trying to find out
a viable a solution to this. About 11 days back, I had been to Nagaland, specifically in connection, not with this case, larger number of cases, especially the teaching staff. Plenty of them who are qualified. In fact, earlier what we had done was we have reduced the age limit. In Nagaland, if you put in 35 years, you have to retire.
Okay.
Why we had to retire was we made a law saying you have to retire at 35 or at the age of 60, whichever is earlier. So if a person joins at 18 years, he will have to retire at 53. Why we did that was there was stagnation as far as employment is concerned. And many people who joined service, who were supposed to retire at 60, they did some manipulation and they would continue in service for even 45 years.
Bad administration on part of the state.
Yeah, so therefore.
Does that give a right to the
No,
state?
therefore, we came to the court.
Wages even much below the minimum wages.
Therefore, in that matter, we came to the court. And the court asked us, why do you want to do it? So then we placed to the court, we have only two services. One is the government service, the other is the underground service. This is recorded by a former Chief Justice.
Underground service.
Yes, it is recorded in the court and it is further recorded by the Chief Justice of India. I appeared in both the matters. So then they said, we agree with you. You go ahead with this. And that is how several thousands of employment was given for the youth. So we have our own peculiar problems. But in spite of that,
we understand
that we are not, this is not an adversarial litigation. This is a human problem, and we all know that this type of thing is not really too good. So to assuage their problems and to try and bring about a settlement, I have been given specific instructions to come and see if I can work out a policy. And I think if that is done, we are only fearing only one point, to be frank with you. But they say that if they be brought in through some other means, then you can't do it. But today it has changed. We are in a different, notwithstanding Uma Devi's, that may have been relevant at that time. But in what way we can do it? Because the legislature is going to pass the law. So if it will again be tested by this court or by the higher court,
yes,
that will be looked into. In that event, your lordship may push it off by about 3 months. This is what I would say.
Very well. All right. Do that. And otherwise also, the learned single judge has just asked you to decide their representation. Nothing beyond that.
No, we have one important issue, by the way. One learned judge says that you are not entitled to regularization, number one. And the party themselves say under the notification they are not entitled. The coordinate bench, which hears the matter, goes into it and virtually sets aside an order passed by another single judge and says you regularize them and give them pensionary benefits.
All right.
I mean,
Which is that order? Which is that order?
This is order.
Order under challenge.
Page 37 of clock.
All right. So the other order you are referring to is at page number 62. The one which favors you.
No, my lord. I am talking about. I'm not talking about what favored me.
The view taken by the other view taken by.
That's right.
That is at page 62.
Page 62.
Yes, yes.
Kindly see, madam, because these are also issues to be gone into.
That's right.
That's
All right. So
page
we
64.
will postpone this matter by 3 months. In the meantime, try to come out with a policy decision whereby the plight of these persons can be addressed.
That is one point.
Yes.
But this court also has to, honorable court has also to look into this as a question of judicial precedent discipline or what word may be used.
Yes, yes.
Single judge has the freedom to differ. Any judge has the freedom to differ.
Refer it to larger bench.
Yes, larger bench. Whereas here they are sitting on it, and kindly see page 27, madam. Kindly see page 27.
That's right.
It may create a lot of confusion in the minds of people. There must be some uniformity. Lordship would see page 27, my lord. I just read that second paragraph. Thus, those who are less fortunate do not apply to pay scale and given such does not have any chance of regular appointment, even in the near future in the office memorandum dated such and such. Even if the employee serves for more than 30 years, there is absolutely no rationality in granting scale pay or fixed pay, as no test is conducted. There is no yardstick to measure as to who can be granted and what is to be appointed as a contingent employee on a fixed pay. Thus, the office memorandum, which provides that services of employees who have served for continuous 30 years, enjoying pay scale, may only be regularized to discriminate, not in conformity to the provisions of 14, 16, 19 of the Constitution. Completely against Uma Devi's judgment. Obviously, it is also against the ratio laid down by the apex court in all the
So
above.
we'll defer it by 3 months.
Ju-
Come out with the policy decision.
Just 1 minute, let me read. The same being against such and such. The petitioners have not challenged the legality of the referred order, and therefore what has been discussed just remains in order. However, when the facts of a particular case clearly exhibit that the office memorandum runs counter, the same will not inhibit the court from granting relief, and then they gave a direction, regularize. That is an issue, it's a legal issue. We may do our job, but these things matters have to be clarified only on this point.
Yeah, you're right, you're right.
May I humbly submit, Lordship, this was pending before the High Court Kohima bench.
Yes.
The Honorable Chief Justice sat at Kohima bench, and then he himself, once disposed of, took up the matter here. And now it's pending. Now, when this case was filed, the petitioner had 4 years in service. But due to this pendency, Lordship, they have already retired on 35
Cross the age of
to
superannuation, yes.
21. They have already retired. Lordship, I humbly pray that they may not be clubbed up together along with the rest of the
No, we are not,
in service.
we are not clubbing anything.
Yes, so
Mr. Balagopal, Lord Advocate General only request that we may defer this matter. In the meantime, the state government would come out with some policy which probably can alleviate their issues, their troubles.
Lordship, so at the time when the this matter was passed, the respondents were directed for regularization of the petitioner service, but now they are no more in service. I just pray only for the benefit of pension benefit, Lordship. Only that.
Pensionary benefits can only be granted once the order of regularization comes into.
Yes, Lordship.
That is affirmed. Without that, we can't do.
On page 63, they themselves, the learned counsel has said, we are not covered. That's the end of the matter. We are not covered under the notification.
Here what has happened is the respondent government brought out a scheme of regularization for work charge, casual, temporary, and any other service. Now only that contingency was not inserted in that.
Not continued.
Even the work charge
many
are
not
getting regularization after 30 years of service. They don't have a service right, but they are under the scheme. How about us appointed in 1986 as the first, when the first office was opened? Then there were other appointments. There was sanction post.
Yes.
They afresh appointed other person, and we, the first one when the DEO office was opened at Zineboto district, we were the first chokidar, we were the first peon appointed when the office was opened.
Right.
But our consideration was kept aside. They appointed other new appointees. That is how we were retired with 2000, Lordship, 2000. I just pray that Lordship will kindly, now since I'm not in service, I cannot argue much, but just on the basis of 2017 one SCC Jagjeet Singh case, I just rely my case to kindly consider my case on page 58, Lordship.
Yes.
Just on that.
Yes.
And we have retired three years back.
That's right. That's really painful.
Lordship,
But, Madam, the issue is that the argument which is coming forth from the Advocate General regarding there being a different view by the learned single judge and the view taken by the learned single judge in this judgment under appeal, running contrary thereto without the matter being referred, that is a substantial question. We have to address that issue.
Yes, Lordship.
We may take a view which has been taken by the single bench, but it was not within the domain of the single bench to take a different view without referring to the matter. So we'll consider it. The Advocate General, Mr. Balagopal, submits that the state government is contemplating coming out with a policy which can assuage the plight raised by the respondents here in the direct proceedings. He prays for and is granted 3 months to place the proposed policy on record. List of after 12 weeks. All right.
Please.
12 weeks.
12 weeks, please. If we get at least one little latitude that in spite of the inhibitions imposed by Umadevi case, certain matters could be looked into, then I have a free hand. That's the only problem coming in like that.
That's
Somebody should not come tomorrow, or another group would come and say,
naturally.
Umadevi said this, 5 judges bench, and you did this. This is our concern.
That's right.
Otherwise, there's no problem.
Lordship, just one humble submission is that I'm doing this case, the petitioner got to 2000 and retired. I'm doing this case pro bono. So kindly allow me to appear through video conferencing.
Madam, Guwahati High Court is allowing VC facilities to every council, at least from when I joined this court.
Lordship.
So we have not denied
Obliged.
anyone.
Obliged.
We have heard a writ petition wherein the challenge was given to the power of the Chief Justice to transfer the cases
Lordship.
from the bench to the principal seat, and we heard it by VC. So you are always at liberty.
She has appeared many times on VC.
So
Appeared many times, but then Lordship sometimes.
but you know, appearance in person has a different impact. That is for sure.
Yes, yes, that is the right thing, Lordship.
Yes.
Humbly obliged.
All right.
Yes, please carry on.
Item number 20.
In this case, my lord, notice was issued and the other side was asked to file affidavit. They have also taken time on several occasions. to file affidavit. No affidavit has been filed.
Yes. Who's appearing? Mr. D.K. Sharma was appearing earlier. Affidavit on behalf of the state authorities has not been filed despite ample opportunity being provided.
After some time, my lord. In the meantime,
They're being provided. Last opportunity is being provided to the state authorities for filing their affidavit in this.
This has been looking after by DK.
We are giving you time.
MDS.
Last opportunity of 6 weeks is provided to the respondents for filing their affidavit. List after 6 weeks.
Item number 23.
Yes. Is that land matter? Yes. What has happened?
The authorities are still, my lord, endeavoring upon, my lord.
Oh, are you searching for a plot of land on the moon or what?
No, my lord, here.
Then?
It is very difficult, my lord.
What is difficult?
My lord, lands are available, my lord, outside the, my lord, the municipal area, far away from the Guwahati city, my lord. But in Guwahati city, it is
Ask
very
your client, then you give him a proportionately larger plot. You can offer that. Ad valorem, you can calculate the value of the plot in the area where his original land was located. And then ad valorem, a larger size of plot may be offered.
That aspect of the matter is also being looked into. They are taking all options, my lord.
What else can be done, gentlemen? If there is no land available, you will have to go to a little distance.
Land is available, but my lord, the authority concerned.
You already file an affidavit that lands are available here with the relevant revenue documents. We give you the opportunity. Do that. Come out with an option.
My lord, the authority is concerned is the owner of the land, and how
you tell us which plot of land is lying vacant. We'll ask the authorities why you are not allotting that.
My lord, 2 weeks time, my lord, I will provide.
Current counsel, Mr. Pujari submits that till date, the authorities have not been able to identify a suitable plot of land within the precincts of the municipal GMC for being allotted to the petitioner by way of respondent, by way of settlement. He prays for and is granted 4 weeks time to place the latest factual report on record.
I'm so obliged.
Supplementary list, item 29.
Yes.
My lord, may I pray for a little accommodation, my lord? We have got some documents, my lord.
All right.
My lord.
Mr. Boyan,
my lord.
prays for some time to argue the matter. To take note of this objection, Learned Government Council has raised an objection that the advertisement based whereupon, the appellants have claimed relief, does not indicate the number of posts which were being advertised. First up, Mr. Ayadwan prays for some time to respond to this pertinent objection raised by Learned Counsel, Mr. Bora. List up 4 weeks.
Item number 30.
What is the
matter? There is some issue with the boundary of the Schedule A property. Lordships have stayed as far as the Schedule B is concerned. But we need some more time. Let me stay as far as B continue. We need some more time to carry out because we are cooperating with the ADC revenue. He is doing the needful. Lords will issue the appropriate corrigendum, etc., and redo the entire process.
Mr. Ganguly submits that the bank officials are in consultation with the revenue authorities for removal of discrepancies in the boundary of the property, Schedule A property, and that the issue is likely to be resolved within next 4 weeks. Let's, after 4 weeks, explain.
The interim order.
Interim order passed earlier shall continue.
Top of the list matter, item 1 and 2.
May it please, Your Lordship.
Yes.
My senior is on his way from a different court, Your Lordship. Can you just grant us leave of a couple of minutes? Just a couple of minutes, Your Lordship.
What is the matter about?
This is a matter which has been pending. The post-based reservation in Assam was challenged by the petitioner, and they took the plea that the reservation could not have been given because of nepotism and Article 14 and 6. Well, it's a misconceived petition. In fact, the government, the Additional Advocate General, Mr. Majumdar, has also supported our case, and we are for the reserve. Well, they want to bring the entire edifice of reservation in Assam. And in fact, we have challenged it on the ground that they don't have the locus.
Okay. Hmm. Are they targeting a particular recruitment or in general?
No.
The challenge is in general.
This, I may submit.
Mm-hmm.
This amendment to the Assam rules has been challenged. Now, this amendment was made in the rules to introduce post-based roster, not vacancy-based.
Okay.
And this is based on the judgment passed by Honorable Supreme Court in the famous case of R.K. Sabarwal. Now, unless the R.K. Sabarwal is modified, this amendment can be challenged, my lord.
Natural.
Validity of this constitution.
In fact, there is a division bench order of this court.
IV Gohen Gupta.
Yes, IV Gohen covers all the points. And in fact, there is a division bench order of this Honorable Guwahati High Court 30 years back. Same rosters were challenged, rejected on the ground that legislative competence is there of the Assam government to bring in the Act of 78.
We'll pass it over. Let Ms. Chaudhary come.
Yes.
Pass over for the time being. Yes.
Item number 5.
May I please, Lordship? But if these appeals were heard in part on an earlier date, 2 Supreme Court judgments were relied upon by me. Lordship had granted time to the respondents to go through the judgments. The matter relates to the goods will acquire the nature and character of capital goods only when it is used in the factory of the SSC.
Where is Mr. Kale?
I suppose he is on legs in another court, Lordship.
Mr. Kale and Standing Counsel, Mr. Kale is not available when the matter is called out. Re-notify after 4 weeks.
Obliged, Lordship.
Item number 6.
On behalf of Mr. K. Lordship, I am praying for adjournment of this matter, Lordship. It was a sudden development.
Mr. Das, have you given your expert advice to Mr. Saikia how to win the semi-finals? He seems to be performing too well.
Yes. Actually, in this particular case, we are on the same page. So the opponent we need.
Yes. What do you say? What is the controversy, Mr. Saikia?
Absorption of a central government employee in the state service.
Okay. Okay.
And the government wants it, and government have given it.
That medical.
Yes. Medical. Without affecting anybody's service career.
So request is made to adjourn the matter on behalf of Senior Counsel Mr. Ken Chaudhary, appearing for the respond number 1 in both the appeal. In this appeal, Mr. Saikia, Senior Counsel Mr. Saikia, representing the appellant, does not have any objection. list on, let it go to January then,
Lordship.
list in the month of January. Okay.
Deeply obliged, Lordship.
For hearing, item 24.
Yes.
Immediately. May it be lordships. Question, perhaps recall the matter, this matter related to seeking of compensation for prisoners who have been, who have fated or untimely death in the jails of Assam. Lordships. On the last occasion, we were directed to file a detailed chart, which we have done while our affidavit on 15th of September 2023, Your Lordship.
Yes, yes.
If I may take Your Lordship to that particular affidavit for a moment.
Yes.
Lordship, in the PIL, we had subsequent to various orders passed by this honorable court, we had stated that there are 29 unnatural deaths which have occurred. To that, 3 of them they have accepted. Yes, three are unnatural. Rest they are all disputing. Now, from the chart which I have filed,
So this is now basically an issue of identifying the persons who are met with the unnatural death.
And the chart which I have prepared, Your Lordship, if Your Lordship will go through that, then it is apparently clear which deaths can be identified as unnatural deaths in terms of the NHRC guidelines, Your Lordship. It is the running page number 987 to 997, Your Lordships, my affidavit. I am taking Your Lordship to the relevant portion at page 990.
990.
Yes. This is the chart which we have prepared, a comprehensive chart, Your Lordship. Serial number 1, pulmonary thrombosis, no dispute, Your Lordship. It's fine, it's a natural death. Number 2, Amir Ali. Now, Your Lordship will sign.
990, we don't have any page. 990.
Lordship,
Our pagination ends at 987. 986 rather.
And smooth affidavit of pagination 15. Lordship, in fact, we had.
Not a part of pagination there. Seems to be a chart.
2 affidavits which were filed on the same day, Your Lordships.
25/8. No, there is one affidavit on 20th January 20.
No, Your Lordships. 15th of September 2023.
Oh, no, 4th August 23.
Subsequent.
22nd August, one is the affidavit by Biju Datta Chaudhary.
No, Your Lordships. Again, thereafter, Your Lordships, 15th of September, we have filed. Pursuant to Your Lordship's order. We had initially paginated it incorrectly, and then the registry asked us to correct it, Your Lordship.
987, we don't have any affidavit by the, which can be identified at page number 990 as you are saying.
Lordships, in that case, could it perhaps be page number 968 to 970, the affidavit, and 971 to 978, the annexure, Your Lordships? Perhaps.
Just
because the registry had asked us to repaginate, Your Lordship. That is why we were a little confused ourselves.
We'll identify it from the date, if possible.
Yes, Your Lordships. I'll be deeply obliged. My affidavit was filed on 15th of September 2023.
No.
Not on record?
No. There is one affidavit shown by Pubali Gohen.
No, that is the affidavit of the state, Your Lordships.
Is that so?
Yes.
Okay.
Pubali Gohen was the state affidavit.
And
ours is sworn in by Dr. Biju Datta Chaudhary, Your Lordships.
4/8. Oh, it's not there, madam.
Lordship, that is quite.
Main file mein check kariye.
Lordship, I do have an extra copy of the affidavit if perhaps that might.
We'll take note of that.
Lordships.
Ms. Saiki, are you having a copy of the affidavit?
960.
I have a copy of this. The pagination here is to 968. Biju
Yes.
Datta Chaudhary.
Yes, yes. Yes, pagination is from 968.
Lord.
That's right.
Lordships.
But
Then in that
even,
case, it will be
even
971.
that doesn't match with our record. Anyhow, doesn't make any difference. Because that
The chart is there.
chart is there.
Chart
What do you
is-
say, Mr. Saikia? So the chart.
But they have to come individually because some of have approached, because now if they are actually pursuing the case for compensation.
Supposing we are in the PIL jurisdiction and
Exactly.
we find that there are unnatural deaths. Why can't the state take a
They,
general
some
policy?
of them have already approached and they have received it from the Human Rights Commission.
Only three, only one.
So let them go individually. Lordship may give that observation.
Anything.
But we don't know, Mr. Saikia, whether individually they will have the capacity.
But
to-
most of them, they're dead, your lordships.
they
Then
are-
who will receive it?
who will receive? That's again a problem.
For the
Yes.
Kin, your lordship, the next of kin. The next of
We
kin
don't
is
even
like-
know.
Your
They are
The lordship, that is
If
why
they are-
the chart was,
what,
that was why
what
we
we
were
can,
asked to.
what we propose then is
Lordship,
that based on this chart,
lordship,
we direct the DLSA concerned
lordship,
to approach the family members
lordship,
and ask them to file an affidavit in this very petition.
Lordship.
lordship,
If they are interested in seeking compensation. So
lordship,
at least we can identify whether the kith and kin are there who are
lordship.
entitled to receive the
Correct.
compensation. But supposing we award the compensation, who receives it?
Lordships, my humble submission for your lordships would perhaps be
Hmm.
that quantum may perhaps be fixed in cases of unnatural deaths by your lordships. So if a next of kin is available,
Hmm.
well and good. If
So
it
do
is
we have
not,
a-
then
do we
as
have-
has been done by the
Do
honorable.
we have a
Supreme Court.
reference to any guideline? How to
Lordship, there
fix
is
the
a-
quantum?
There's a judgment of the recent judgment of the Shillong High, of the Meghalaya High Court, your lordships, wherein they have said that in case the next of kin is not available, it should be granted to the compensation, should be granted to the cancer hospital concerned.
Forget about that.
We may perhaps not-
Quantifying the compensation.
Lordships.
How do we quantify?
Quantification is always the discretion of this honorable court, your
No, it can't be,
So far
can't
as
be.
the, I
It can't be, it can't be a general exercise.
Lordship, I have-
Ultimately, what we feel is that the quantification should be based broadly on the parameters of the motor accidents claims,
Lordship.
depending on the age, the dependency.
Dependence, lordship. Also another, so in the Meghalaya High Court judgment, they have categorized into three categories, your lordships, less than 35, 35 to 45 and post 45. And that is how they have granted compensation. I'll place that judgment before your lordships. Your lordship will- they have seen.
But before we indulge in that
Your
direction,
lordships may also, like I had said on the last occasion, your lordships may perhaps also be able to draw an analogy from the victim compensation scheme,
yes.
where death, whether the quantum of has already been quantified for a death case, what is the quantum which can be given as compensation? So taking that as an only to draw an analogy from there, lordships, because that scheme is already there and death has been the quantum of compensation which can be awarded in a death case has also been specified in that particular scheme. Perhaps your lordships could draw an analogy from that insofar as your lordships are the query which has come from your lordships as to how to quantify.
Why not a better way out? MSCT, it's a 70-year-old man. He falls down, gets a coma or a head injury and dies. In MSCT, he would not be entitled to any substantial compensation.
Correct.
So why shouldn't that be the yardstick?
Lordships, because
Because
this is
victim compensation, it will be a general compensation for every death. We can't
lordship,
make all
your lordship,
situations equal.
correct, lordship. But the problem is that some of these people are declared foreign nationals. They have died in incarceration, your lordships.
We understand.
And have perhaps been subjected.
And supposing
Lordships.
none of their kith and kin are in India, who receives the compensation?
Lordship, perhaps then the compensation which may be allowed to be granted to them may perhaps go to the state's legal services for others to benefit your lordships. Because the state is as it is in a financial crunch insofar as the salsa is concerned. They are not even giving us the money concerned. So if at least some basis is laid down and some amount of compensation is granted to, if it is identified that a person has died an unnatural death, then a quantum should be granted. And if the next of kith and kin is not available, then that sum should be given to the
Like
legal aid services.
what we'll do is, we will make an observation that the state government come out with a response to the proposal that the compensation should be quantified on the basis of the parameters in the MSCT cases.
Lordships.
We think that will be the just and fair compensation.
In that case, that multiplier scope is there, but only a thing is that what was their income?
Yes, so
All these
for that
factors.
they will have to satisfy. The claimant will have to satisfy.
That what
Plain
we were
and
doing
simple.
in Bangladesh.
Otherwise, yes. Otherwise, the bare minimum compensation. That's how the things will work out.
Yes, that is a policy decision, Lordship will direct, will
We
definitely
will,
implement.
we'll just ask you
Yes,
to take into contemplation
yes.
whether the compensation can be
Each
quantified.
individual case has to be assessed.
Yes,
That is
yes.
the case.
In terms of the
Fact
chart.
finding
Your Lordship,
exercise has to be done.
in terms of the chart.
Some level.
That will be a general direction for each death.
For each death.
All right.
Lordship.
After hearing the learned counsel for the petitioner and learned advocate general, comma, we hereby propose the following questions for consideration of the state government so as to take a policy decision for quantifying the compensation to be awarded in cases of unnatural deaths of prisoners incarcerated in prisons. Number one, whether the compensation awarded should be in tune with the compensation as proposed under the Victim Compensation Act. Number two, whether the compensation should be quantified based on the parameters as provided under the motor vehicles, motor accident claim cases. Number three, whether individual claims are required to be filed in cases where compensation is sought for any prisoner meeting unnatural death inside the prison. Come out with the answers, and then we'll see.
The difficulty is, Lordship, they're not even willing to accept that they are unnatural deaths. That is the difficulty.
No, there are natural deaths. Most of
No,
them,
no,
90% of the deaths are natural.
For that matter,
Cardiac arrest can be
once
a
the
natural death.
quantification is there,
Lordship.
the claim will come in, and then we'll decide.
Lordships, I'm
Yes.
deeply obliged, Lordship. He said.
4 weeks time may be given, Lordship. We'll
4 weeks time is granted.
Highly
to the Advocate General for responding to the above queries.
deeply obliged.
Deeply obliged, Lordship.
Item number 25.
Number three, in case of there being no kith and kin of the victims, whether the compensation so quantified can be paid into the funds of the Assam State Legal Service Authority.
Also, or the otherwise slash, your Lordships, the infrastructure which your Lordships are looking into. For
Lordship, that is a
infrastructure,
totally different area,
I'm
Lordship.
just saying. it's-
Cancer hospitals,
In
cancer
case-
hospitals they are already funded by the state government.
Lordship, for also, Lordship, there is a different channel.
There's a fund already provided.
So,
Already. Leave this last one. Leave this last one. Yes.
Highly obliged, Lordship.
Deeply obliged.
May it please your lordships. I am led by Mr. K.N. Chaudhary, sir, in this matter, lordships. He is not available today. I may be allowed to start, lordships, but we pray for an accommodation to continue on Tuesday, lordships, so that he can conclude the matter. I will only take your lordships to the factual permission. lordships. Sorry,
Yes,
Thursday,
today-
lordship. Today is Tuesday, Thursday the 9th.
In view of the intervening circumstances, Mr. Day, probably it will be difficult for us to decide the matter. Though, of course, we were really intrigued by your arguments. We must appreciate that it was really an interesting line of arguments, which perhaps very rarely one can come across.
Facts are very peculiar.
It's really very interesting and very enlightening, to say the least.
My lord, in the beginning of the day itself, my lord, I had an inclination to tell that this day might be too good for this case. Which we frame.
As a matter of fact, really, we were enriched by what you said, what you projected before the court the other day. It was a totally new subject.
It's a new
for
subject
us.
for me also.
It was very interesting. But probably now to continue with the hearing would not be fruitful.
Yes.
So all right,
Might not.
as jointly prayed, list on date,
My lord, maybe on December, my lord.
whatever date you see.
My lord. For your out of session. My lord, after the vacation.
You just say the date from the calendar.
14th of November.
No, after the vacation.
That will be good.
December
Will
vacation.
not be there.
You want after the December vacation?
My lord, there's only one vacation we have now.
December.
December.
The other high courts have Deepavali vacation also.
Yes.
All right.
Maybe-
This in the second week of January, 2024.
Oh, sir, may it please your lordship, sir is not available around in January, lordships. It may be the last week of December, may be accommodated.
Last week of December will be vacations, madam.
Just before that vacation.
My additional advocate general will be out of session, my lord.
So let it be in second week of January. Then you can perhaps again talk to each other and
My lord,
fix
yes,
the
yes.
proper date as per your convenience.
My lord, my lord.
Thank you.
Deeply obliged.
Deeply obliged, madam.
Item number 26 to 28.
Gopal,
Please, madam.
final hearings. Final hearing matters probably it will not be possible for
No
us to conclude. So when do we list it? Madam,
Lordship, I pray that it's just a short matter, Lordship.
You won't sign.
I just
it will not,
simply
we
beg.
have got few judgments to complete. It will not be possible for us.
Understand the court program. Keep it any day, you know. And we also want to convey to your lordships the very happy expected news and heartiest congratulations from all of us.
As jointly prayed list on. Say the date
Immediately, Lordship.
whenever you want,
At my Lordship,
subject to his convenience, of
Keep
course.
it in January, madam.
not January this year, please, I humbly beg, Lordship. Lordship, my Lord
keep
will
it in
kindly see
December.
that it's been pending
Keep
since
it in December.
2016.
It's not that I'm not prepared.
This appeals are of 2023, madam.
Yes, that is after they taking time for more than 2 years. They
Not
came
we-
for appeal. Review also dismissed.
We have taken note of certain facts when we admitted the appeals. They are very important facts. We distinctly recollect. So, all right, we'll fix a date in December. If convenient, please address the
Lordship, Lordship.
Second week of December.
14th of December.
14th.
Okay. Thank
you. Public.
Published, Lordship.
Passover meter 1 and 2.
Sorry, my lord, I was on legs in a report.
Chaudhary, as per Mr. Das and as per Mr. Mazumdar,
My lord.
in view of the judgment of the Supreme Court and IV Gohen Das Gupta,
My lord.
the controversy is covered. What do you say?
My lord, in this case, the act has been challenged, particularly, my lord,
The provisions of the act are in line with the Supreme Court judgment,
my lord,
as is being referred by Mr. Das.
my lord, yes.
So then how this court is supposed to intervene?
My lord, also from the Supreme Court judgments that, my lord, the reservation in promotion cannot be had without collecting the quantifiable data and, my lord, the state forming an opinion. That is the, my lord, settled law by the Supreme Court. So I'd like to, my lord, take your lordship to the decision of the Honorable Supreme Court.
All right, then we'll fix it in January again. List for hearing in third week of January.